All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We are here in the matter of Kenneth and Sally Ritchie versus Tim Costello, Cottonwood Municipal Airport et al. Our cause numbers CV140185. This is the time set for oral argument. Each side will have 20 minutes. Appellants, if you'd like to save time for rebuttal, we'll let you manage the clock. This hearing is audio recorded, so as you come forward, both, please identify yourself and your client. We're also videotaping, and apparently this gets posted on YouTube. I don't know that anyone's ever seen it, but maybe you can put it to music and have a good time. We have read the briefs in this matter. We've conferenced the case. We seem to understand the issue that is being presented from Judge Budner's rulings. And so with that in mind, counsel.
Good morning, Your Honors. My name is Kyle Sherman. I represent the appellant in this case, who is Dr. Kenneth Ritchie. We're asking that the trial court's ruling be reversed. And the root of the trial court's ruling is restricting the concept of duty to property boundaries. Now, this court has already recognized in Stevens v. Vashes that the concept or the principle of duty is not going to be restricted simply by property boundaries. And
well, is it then an issue that we're talking airspace, that we're talking federal control and potentially preemption?
Not necessarily, Your Honor.
Okay.
And the reason being is that the control of this particular situation is the airspace surrounding the airport owned by the Cottonwood.
But who was controlling anything, maybe you can help me with information. Was there, for participant hot air balloons or others, was there a registration process, or were people just told to show up on the morning of Airfest and take off?
That is actually the issue that is at stake. Who was in control versus...
Do we know, well, what does the record show in terms of whether there was a registration process for vehicles that were going to take off?
From my understanding, Your Honor, there was no registration process. There was an invitation for these individuals to come and participate in this particular festival. That was put on, it was run by, it was controlled by the Cottonwood defendants. And control is actually the issue here. Now, the trial court's ruling restricts the process of duty to a particular ground within this area. Now, I would say the irony under these circumstances is that, from my understanding and reading of both briefs, both parties disagree with the logic behind the trial court's ruling. And if I may explain, on page 8 of the response brief, the appellants agree that there are at least 3 duties that are owed under these circumstances. Number 1, to discover and correct or warn the invitee of unreasonably dangerous conditions. Number 2, to protect the invitee from physical harm caused by the acts of third persons. And number 3, to provide the invitee with a reasonably safe means of ingress and egress. Consequently, all 3 of those duties are implicated in the facts of this circumstance. The very nature of the claim behind Mr. Ritchie's claims against the Cottonwood defendants is that this Airfest was in utter chaos. There was no control where there should have been. There was no mechanism provided for the safety that should have been present.
Safety in the air.
I'm sorry?
Safety in the air.
Safety in the air, safety on the ground, safety taking off, safety landing.
Well,
Absolutely.
Everyone took off safely, and they, as I understand the record, they moved him around 2 or 3 times to ensure that he could, in fact, take off safely.
That was, well, Well, actually, Your Honor, if I may, Mr. Ritchie moved himself. After there was utter chaos on the ground, realized that his mechanism of being able to take off was going to be blocked by somebody else who had just kind of rolled in front of him. He moved himself.
I'm
to be
assuming
able to
that's a
take
hot
off.
air balloon.
Yes,
Okay.
correct.
And I understand other than his paraglider and his son's paraglider, everything else were hot air balloons that were taking off.
Yes, correct. Now, Your Honor had mentioned that everybody had taken off safely. That's not entirely correct either, because there was one balloon that was a straggler who wasn't properly informed, and that balloon ended up and was still on the process of ascending or egressing from the property below. And that's the balloon that Mr. Ritchie ended up getting hurt by. That's where the accident happened. That wouldn't have happened had the duty of proper care been taken into place. Now, I understand that there are certain facts that are in dispute, but all three of those duties that are agreed to by the appellants in their brief are implicated factually. Now, they are in dispute, which would preclude summary judgment under these circumstances for those facts.
When you say they're implicated factually, I need you to flesh that out for me some more, because I guess I have the impression that Mr. Ritchie had been flying for some 30 minutes or so, and that he was a quarter-mile away.
Your Honor, he was in the air for 30 minutes, correct. He was not in the air away from the grounds. There is time that he has to use to be able to get to the proper ascent. He needs to reach that proper ascent, and then afterwards.
Well, how far up into the air do you claim the premises of the airport extend?
Well, under these circumstances, because of the nature of what was being put on, through the entire time that Mr. Ritchie is actually flying. That's our contention. Mr. Ritchie...
So 5-10 miles away could have been. He could have gone 10 miles away, and the city would be on the hook?
Under these particular circumstances, yes, Your
Because
Honor.
the city sponsored the Balloon Fest.
Yes, and that is correct. Mr. Ritchie was
Did the city undertake to ensure the safety of people in the sky, in the air?
They should have under these circumstances.
How would they do that?
Because the relationship between the parties was such that they could have provided the mechanism to be able to ensure safety. They could have provided, as Dr. Ritchie testified in his deposition, on many occasions, on several other occasions, he had been involved where many other aircrafts were involved. Prior to taking off, the organizers of those events would come in, they would sit down, they would prepare a map, they would provide mechanisms of control, they would provide mechanisms of communications, which was absolutely key. And those mechanisms were not anywhere to be found for this festivity.
Communications like what? Like everybody was provided is it your contention everyone should have been provided a radio?
Or, to my understanding, these individuals have their own. But they should have been provided a central mechanism to be able to communicate together.
On the frequency.
Yes, correct, Your Honor. And there should have been somebody on the ground from the airport that provided the communications to each individual that was available. They didn't have to provide radios to each of the individuals because they had those themselves. But they should have provided the mechanism to be able to properly and safely communicate back and forth between the ground and themselves when they're up in the air.
Does the airport operator, owner or operator, have legal power to tell people flying balloons and paragliders how to do it when you're 10 feet, 20 feet, 1,500 feet off the ground?
Not that they necessarily tell you how to do it, but how to remain safe while doing it. And that's the key here.
Well, wouldn't it be just pay attention around your surroundings?
No, Your Honor, because under circumstances like these,
Okay.
the individuals may not have a peripheral vision below themselves, as was the key here. Mr. Ritchie could not see in front of him. He was in a sit-down powered paraglider, which meant that his vision was to the right, to the left, in front of him. Very seldom in the back was he available to look, but also below him. His feet are right in front of him, so to be able to look directly in front of him and below was next to impossible. Safely done. Had he had the proper communications, had he had the proper instructions, the proper pattern to be able to fly in the air, that may not have happened.
When you say pattern, I don't understand what you contend.
During his testimony of deposition, he testified that this wasn't the first time that he had been to the Cottonwood Airport. He had taken off from the airport before. He had talked to the individuals who were in charge of the airport. It's uncontrolled. But based upon his communications with the individuals, getting a pattern of flight to be able to get up, move around, and safely get out of the way is key. That's exactly what needed to be done. Now, none of the instructions were given at the beginning of this particular Airfest.
Were there instructions the night before or a couple of days before, or do we know?
None, Your Honor. No instructions were given whatsoever. So Dr. Ritchie's takeoff consisted of his previous conversations and previous experience of taking off from the Cottonwood Airport. He had used the same pattern that was given to him beforehand, and unfortunately, that resulted in disaster in this particular situation. The key here is with regards to the relationship. Now, this is not, and what I would submit is that this is not a simple relationship or a regular relationship between an uncontrolled airport and somebody who is just coming on as a pilot to use it. This was very different. The Cottonwood defendants extended their relationship. They extended their services and authority in this situation, excuse me, maybe not authority, but definitely their services and what should have been their duty to the individuals who they invited to come on. This was going to be a big event. They wanted it bigger and better than the last year or the previous years that they've had it. They invited individuals to come on as exhibitionists, to be able to show off and to draw in crowds so that they could show, or that the crowds would come in and that they would participate in this festivity. To be able to do that, they invited individuals to come in, and Dr. Ritchie was one of those individuals who was an invitee to participate so that these crowds could be drawn in to this situation.
How did you, I'm sorry, go ahead.
They specifically invited owners of paragliders.
No, Your Honor. The invitation came indirectly to Dr. Ritchie through his son. Dr. Ritchie's son, Scott Ritchie, was directly invited by one of the individuals, and I understand that this is one of the contested facts. But again, that goes to the fact that summary judgment should not have been granted in this situation. But
what was contemplated here besides, I mean, was there contemplated for biplanes or, I mean, regular airplanes? Was it just a balloon? Was it primarily a balloon fest? Not necessarily?
No, Your Honor. It's called an air fest. And so they had invited, obviously, balloons to come along. Scott Ritchie was invited with his paraglider. He then was invited to invite other individuals, including his father, who were powered paragliders. They were going to have, I believe, another glider that was coming in. There was supposed to be a touch and go from another plane. This was going to be an exhibition of different air display. It was an air fest for the airport, not simply balloons. It was going to be for other exhibitions, and Dr. Ritchie was part of that.
And I understand he was invited or working with a friend to take pictures of a friend's balloon.
The night before, they had met with this individual who had met before, and so yes, one of the keys was that, or one of the suggestions was that he was going to take a picture if he could. It wasn't going to be an absolute, and Dr. Ritchie testified to that in his testimony, in his deposition testimony. If he could, if it's reasonably safe, then yeah, he would get the picture, and that would be that.
Did he get the picture?
My understanding is that he took the picture. Whether or not it actually came out, I don't know.
Whether it survived?
Yes.
Based on what you said earlier, then he would have had to turn left or right to take the picture, and not because you said his vision straight.
That is correct.
straightforward is obstructed.
That is correct. So he would, and I believe that his testimony was that he was turning to the right. His camera was readily available. It was on. It was in his lap. It would have been a simple point and shoot, and that would have been that.
My impression, if I may, is that you're arguing that the relationship is extended, I think is the word you said. The normal relationship is extended, and I think I understand you to be saying extended so that to the extent this fits within a premises liability theory, the premises are extended.
Yes.
And that at least among the facts that you are looking to support this extension or the expanded relationship are the invitations.
That's correct.
The invitation to Scott and an invitation for Scott to invite others, and he invited his dad and so on.
Correct. Correct.
Are there more such facts that extend or expand the premises or the legal principles?
We believe that there are, in the fact that, number one, the Cottonwood defendants are the event organizers. They are the event coordinators. They are the event controllers. The defendants organized the Airfest. The defendants extended invitations to the public. They extended invitations to those who would be participating as exhibitionists. They solicited sponsorships. They charged patrons to come in. They wanted a show for people to be entertained, so they wanted to come and participate in this event.
Since the Supreme Court in Gibson changed the law regarding duty, obviously we don't talk about foreseeability anymore.
Correct.
It seems like a lot of what we're saying without using the word is, hey, it was foreseeable you're going to have a bunch of balloons up in the sky, and if you got a few other kinds of aircraft up there as well, there'll be danger. I gather you're not resting on foreseeability.
No, absolutely not, Your Honor, and I would disagree with that. The foreseeability is not the key here. What is the key is the relationship that exists between the two parties.
Well, that's where I kind of wanted to go next. What does the Supreme Court of Arizona mean by relationship now? I understood Gibson to say, well, relationship's still a factor, but we don't want you delving into a whole lot of facts.
No.
So it's got to be sort of up front right away, or else it doesn't count. I'm paraphrasing.
Absolutely. The
And they said that recently,
Well,
yes.
last week.
In the Guerra case, I think they reiterated that. The three members did.
And the relationship between the parties under these circumstances is that of owner and business invitee. That's the key here, and that's what it is agreed to by the appellants on page 8 of their response brief.
But I guess that
And
still
now, once
leaves
the business invitee leaves, then what relationship does the business invitee then have with the owner?
Well, I would argue that the relationship never left. And the reason being is that this court recognized in Monroe v. Basis School the duty owed to another is directly tied to the expected activities within that relationship.
So the relationship exists so long as the Airfest was going on?
Absolutely. Absolutely.
Or so long as there were machines in the air?
Absolutely. Now,
Counsel, the expected activity for schools is that children are going to go home.
exactly.
I mean, does the school have a duty to ensure the safety of the child, the child will arrive safely at home?
No,
I
Your
thought that was the opposite.
No,
in the
and that
basis
was very
decision.
clear in Monroe. The fact that makes this case different from Monroe as to just the facts is that the Airfest was continuing. It was an all-day festival. Dr. Ritchie never left. Dr. Ritchie was still present. He was still participating in. He was doing the activity that he was expected to do, which is to give a show and bring in the crowds. Let them be entertained so that they want to come. That was the activity that was being present or presented by Dr. Ritchie. That relationship never ended, especially after only 30 minutes of flying. The duties held within a relationship can be extended by a party who undertakes to provide additional services or protections. Those were the statements. That was the comment by this court in Monroe. These duties, these responsibilities, these services were extended by this defendant. Now, in irony, in a way, we kind of agree with the appellants that the Cottonwood defendants did not control the immediate space, but the key is that they should have and they could have controlled it. They could have controlled the chaotic mess that they had accumulated on the ground, which then rose up into the air and caused this accident. Your Honors, I see that my time is almost out. I would like to reserve the rest of the time for rebuttal.
Very well, thank you.
May it please the Court, Jennifer Cranston from the law firm of Gallagher and Kennedy on behalf of the Cottonwood defendants, the appellees in this appeal. With me today is Ms. Kimberly Allen, and also Kevin Neal is in the back, my colleagues from Gallagher and Kennedy. So there are two issues presented for the Court's consideration today. One is duty, the other is the scope of the duty. And duty is the first threshold, primary legal issue. The plaintiffs, the Richies, have essentially argued a couple different bases for their duty, and the relationship basis is sort of merging the concept of a premise owner liability with an event organizer. And as the trial court correctly found, there simply isn't a premise owner, pure premise owner liability here, or duty here, because as you know, Mr. Ritchie had been flying around for 30 minutes. He was, at the time of the accident, he was more than a quarter-mile away from the airport, and he was 1,500 feet in the air.
Let me ask you about the quarter-mile away from the airport. I saw that with some interest in your brief. In the reply brief, though, I recall seeing that the point made or argued that there is a factual dispute as to whether Mr. Ritchie was lining up to land.
I'm so glad you asked that, because I saw that too, several places, and let me clarify. The record, which, as you know, being appellate judges, is critical here. So what is in the record? What has Mr. Ritchie's counsel cited from the record for this concept that appears in the reply brief that Mr. Ritchie was in the process of landing at the time the collision occurred? Index of record 143 and 154 are the transcript from the oral argument before the trial court. There's one statement made by counsel saying, "Oh, I think he was landing." The trial court judge said, "I don't remember seeing that anywhere in the record. Could you point it out to me?" He couldn't point it out to him because there is absolutely nothing in this record that indicates that Mr. Ritchie was in the process of landing. The brief also cites Index of Record 121, which is Mr. Ritchie's summary judgment statement of facts. There's no mention in there of landing. As just a practical matter, there couldn't be a factual dispute about whether or not Mr. Ritchie was landing, because he was still a quarter-mile away from the airport, and he's too far away to be truly triggering a duty to make the runway safe for landing. And that's the duty that our courts have recognized in Catchings, is a duty to make that runway safe.
How about to keep the airspace safe as you approach with your base leg and downwind and final approach?
Which
could all be, you could start on your base leg quarter-mile away.
In both our Arizona Supreme Court in Davis versus the Cessna case, as well as the Illinois Court of Appeals in Bishop v. City of Chicago, both address this very same situation, which is you're still a quarter-mile away. You absolutely intend to fly to the airport. You may be making your descent, but there is not a duty owed by the operator of an airport under those circumstances, because you're not in the process of ingress.
Would there be a general duty for the extension of one just because Airfest had invited people and it was chaotic, and maybe the balloon that was involved in the accident got started a little later than the others?
Well, so a couple things. One, the record is clear. No one has alleged that Mr. Wadley, who was the balloonist who was involved in the accident, that he was continuing to launch at the time. Hot air balloons continue to go up, but his complaint, and the record below is clear, he had already finished launching. He was now in his hot air balloon flight. The invitation issue, I think, is important because, again, let's look at what the record says about what Airfest was. Airfest involved several events, all of which were held in the airport premises. There simply isn't anything in the record indicating that this was an aerial exhibition event with, flying stuntmen or anything like that. There was nothing like that. There's a barbecue, there's a wine tent. Pardon me?
No Blue Angels?
No Blue Angels. There's a World War II reenactment there at the airport later in the day.
You mean on the ground?
Yes. But the Airfest bulletin that went out, the flyer, specifically doesn't say anything about a tandem flight involving balloons and powered paragliders. It certainly doesn't say anything about midair photography. And there's nothing in the record that indicates that the event extended a quarter-mile away from the airport premises. At most, Mr. Ritchie was involved in the balloon launch.
Is there
which had
anything in
already
the
occurred.
record as to whether a municipal airport operator, an uncontrolled airport, no tower, is there anything in the record about whether such an entity could exercise some control over aircraft, balloons, gliders, 1,500 feet up, even if they wanted to?
There is testimony in the record to the exact opposite, that of course the airport, even if they had someone on the comm system communicating, they can't control where pilots fly once they're up in the air. That is the pilot's obligation.
But what about a warning that pilots, for better, I guess you call them pilots, all of them, pilots should each have a radio. I mean, just a flyer, a training, whatever, that each of them should have a radio, a communication device to be on. I'm sorry, this is where in the CB days you'd be on the same channel. Okay, you give them the channel number and they can each talk to each other. Okay?
Breaker 19,
huh? That there be a channel where if there's a problem with weather or albeit or somebody being too crowded, that you could radio and say, hey, you in the orange and yellow balloon, will you please, get out of the way?
So a couple of things. First,
descend.
The Supreme Court in Markowitz made it pretty clear that those types of questions, what specific conduct the defendant should or should not have been doing, aren't duty questions. And I think that was reiterated in Gibson, that those are standard of care questions. And I'm happy to talk about standard of care, because I think to the extent that the trial court was correct about the duty issue, he would have been even more correct if he had actually gotten to the standard of care issue, because a mid-air collision between a powered paraglider and a balloon simply is not foreseeable. And based upon Mr. Ritchie's own testimony and that of his son Scott, they fly around balloons all the time. This is not an unreasonably dangerous activity. And so
Sounds kind of foreseeable to me.
Well, if you fly around the balloon, it can be dangerous, as this.
Well, but what our courts say about foreseeability is we look at things like, has it happened before? Is this something that, we would expect to happen based upon prior incidents? And we don't have any incidents here of this type of mid-air collision occurring. And the part of the reason for that are the federal guidelines that are applicable to all pilots, including Mr. Ritchie, of which he knows and should know, and the airport is entitled to exercise some expectations about minimum standard of care, which is to keep that safe distance, to know where the balloon is, and to give it the right of way. I'm sorry, Judge Gemmell.
I'm glad you mentioned the word federal. I've been wondering why there isn't an issue, and maybe it just simply hasn't needed to be addressed yet. But isn't this preempted by the federal government's regulation of airspace and air travel?
The preemption issue was not raised at the trial court. My understanding is you really get into preemption issues when you have a controlled airport, and that is not an issue in an uncontrolled airport. I'm looking at co-counsel. I can certainly find out the answer to that question if you'd like us to brief it.
It's not in the record.
It is not.
No, but to that point, what is the code of behavior that's expected of paragliders and balloons, or airplanes and balloons? Or I mean, is that governed by state law, federal law, common law? There is a federal code, the FARS, and that information is in the record, that dictates who has right-of-way, who's supposed to be doing what, and balloons are also always given the right-of-way. And it is the other pilot's obligation to be vigilant and to keep an eye out for, are there other aircraft in the area, and specifically balloons that are obviously very large and have more trouble steering and moving around. That's why they're given the right-of-way as a logistical issue.
Nobody has argued, though, that some of these federal statutes, FARs, other regulations, nobody has argued that those give rise to a common law duty on the part of the defendants here.
No, that argument has not been made. So I want to back up just a little bit, because I do think in reading plaintiff's reply brief, there were a couple other issues that were raised that I want to make sure. We requested oral argument because I wanted to make sure that I had the opportunity to clarify some of this. This concept that, by holding the airfest and inviting people, that by virtue of that Mr. Ritchie's powered paraglider flight, suddenly his entire flight became part of the event, and therefore the defendants owed a duty to him during his entire flight, I think is specifically relevant to a recent case that we have cited as a supplemental authority by the Court of Appeals, the Busan v. Arizona Board of Regents. And briefly, that case involved the plaintiff's son was a U of A student who was on a travel abroad program in China. While in China, he went on a student-organized trip to Tibet and died of altitude sickness. His mother sued a whole bunch of people, including the Board of Regents, claiming that there was a school-student relationship during the entire study abroad program period, even when the students were off doing student-organized activities. And the court rejected this broad portal-to-portal theory, and instead analyzed just whether the Tibet trip was a school activity. They analyzed a variety of factors, including who initiated the Tibet trip and the level of the school's control over the trip. And the court concluded that the trip was not a school activity, and therefore no duty was owed. And here's why I think that case is particularly relevant here, especially in light of the plaintiff's allegations that his entire flight is owed a duty. And that's because it's undisputed that the night before the Airfest, the Ritchies, Mr. Ritchie and his son Scott, met with Scott Nickel, who was another balloonist, and they made plans for what they would do after the launch. After the launch, their plan was that the balloons would fly wherever it is that the air takes them, and the powered paragliders would follow along. And if Mr. Ritchie happened to get a good shot with his photo, great. But the ultimate plan was so that Mr. Nickel was going to briefly land so that Scott Ritchie could land as well and join him in the air balloon, because he'd never ridden in a hot air balloon. This is exactly the kind of self-organized side trip that was involved in the Buisson case. The testimony about that, just so you have the cite to the record, is Index of Record 129, Exhibit D, pages 27 through 29. there's no dispute that Cottonwood had no idea of this plan, that that was what they were going to do, and certainly wasn't involved in facilitating it. It's important also to note that in order to carry out this plan that, we're going to follow you along, take a picture, all that stuff, is where they actually launched from. The hot air balloons launched from the north end of the runway. The Richies launched from further south. The Richies launched in a northwesterly direction. When the hot air balloons got up to altitude, they started traveling east. So in order to follow along and complete their plan, the Richies had to make a very specific route in order to get to the balloons and follow them. There's nothing that indicates that that's part of the Cottonwood Air Fest. It's much more akin to the Busan side trip.
If your clients had undertaken to provide some safety measures in the air for the balloonists and any other aircraft operators, would that be a different story then, if they'd undertaken to say, you all need to be on this frequency of radio, you need to have a radio, you need to be in touch with each other. If anybody comes within what looks like 300 feet of one another, you need to be on the radio and avoid that. If they'd undertaken to do all of that and get the agreement of all the pilots to do that, would that be a different case? Would a duty be owed then?
It might be. I think the undertaking analysis, that voluntary undertaking analysis, is tricky in light of Gibson. So I don't want to go too far and commit that it would be, because I do think we have been informed by the Supreme Court that we shouldn't be getting into those types of details.
What does that mean about, I mean, they didn't they kicked out foreseeability, they didn't kick out relationship, but they sort of said, don't go very far.
They did, and I think the court in Busan struggled with that, but identified some factors that I think will help this court in realizing that there has to be a cutoff. There has to be a reasonable logistical cutoff for what kind of duty you're going to impose upon, landowners, event organizers. Control is one of them, but the argument that they should have controlled is different from, can you actually control what's going on in the air? And the answer is no. No more than a school can control what its students do when they're driving around during lunch, and no more than an employer can control what its employees are doing after that employee, leaves work and is no longer on duty. The Riddle case is actually interesting. The part that counsel didn't cite in the reply brief actually talks about the other cases that had preceded Riddle, in which the employees were knowingly and often not encouraged, but were consuming alcohol on site, on the premises. And the court said, well, in light of the fact that our precedent is to not enforce an obligation on the employer when they know their employees are drinking on site, in light of the fact that we're not going to impose a duty there, we're certainly not going to impose a duty when we don't have that fact pattern, when the employer doesn't know that the employee is intoxicated or hasn't contributed to that intoxication. But the contribution...
Not all of the old cases are correct.
No, that's true. I think this one got it right, because there's a consistency in, where do you make that logical cutoff for purposes of duty? And the moving a little bit over to the public policy arena, because they do argue a public policy duty. Here, we don't have any authority that would extend a public policy-based duty in this case. And in fact, I think there are several problems with it.
Well, let me interrupt you for a moment. Sure. You talked about Scott Ritchie's plan had, based on the record, were they in the process of executing that plan when this accident occurred? Because there's a difference between going to Tibet, organizing, and then being there, and the youngster unfortunately passing away, and a plan that may or may not have been in the process of being effectuated.
Well, they had done their large circle, according to Mr. Ritchie's testimony, in order to meet up with the balloons and follow them. So if following the balloons,
but the balloon that was going to land, or Was it in the process of doing so at the time of the aerial accident?
What was the, I'm sorry, I don't understand your question, Your Honor.
Was the balloon that they were following and going to take a picture of also in the process of trying to land so Scott could get in it?
No.
Okay.
Oh, I'm sorry. No, that's not in the record, and we don't have reason to believe that. They were going to find a good place to touch down.
Wherever
Yes.
it may have been.
Yes, yes. But away from the airport, that is clear. But the public policy issues here, and we've outlined some of them, but really, I mean, we're talking about a municipal entity here holding a community event, a celebration of, you know, airports and World War II and seeing a balloon launch. Our courts have been clear, and we've cited some cases, that that's the kind of event we want to encourage. We don't want to create a duty that would discourage that kind of socially beneficial activity. I see I only have 30 seconds left. I do want to address one more issue very briefly that was raised in the reply brief, and that was the question of whether this court should it find a duty, which I, of course, don't think you should, but should you find a duty, can you consider the standard of care, scope of duty issue? Because the Plaintiffs' Counsel has said that wasn't properly before the trial court, and there isn't anything in the record. And I just want to remind the court that the motion for summary judgment was actually seeking motion for summary judgment on both duty and the standard of care. And the issues of foreseeability and the unreasonable nature of the harm were briefed and discussed at the trial court. Thank you, Your Honor.
Thank you.
Very briefly, Your Honors, unlike the circumstances found in Boyson v. Arizona Board of Regents, this case involves an activity supervised and run by the municipality, and Dr. Ritchie was participating in municipality-sponsored activity when he was invited and during the time that it was taking place. Now, I know that opposing counsel had mentioned this side trip. Well, the side trip never occurred. And the side trip never occurred not just because of the accident, but because of the chaos that had occurred. That was scrapped while they were in the air. And the testimony by Dr. Ritchie during his deposition was that he got up in the air, he was on the radio with his son, who was also airborne, and the comment was, "Let's get out of here. This is crazy." That was no longer going to happen. They weren't in the process of moving forward with any type of side trip. This was all part of the event that the Cottonwood defendants had put on. Thank you.
Thank you very much. We appreciate your argument this morning. Been helpful. We will take this matter under advisement and issue our written ruling in due course. Until then, we stand in recess.